Guys and gals, we have a big problem thanks to the activist judges on the Second Circuit U.S. Court of Appeals. They just upheld New York's ammunition background check law and in the process created a brand new unconstitutional loophole that other states will absolutely use going forward. Hey everyone, welcome back to Guns and Gadgets, your premier source for Second Amendment news that you won't hear anywhere else. And Patriots, we got a major development that came today out of New York. Well, you're going to see this tomorrow. I'm recording it kind of late at night, but it's one that every gun-owning American needs to pay attention to because you might see it rear its ugly head in your neck of the woods. The Second Circuit Court of Appeals just upheld New York's so-called ammunition background check law. That's right, the same system that's been failing gun owners since the moment it went live last year. The same one that caused massive delays, denied lawful gun owners ammunition purchases, and added new fees. Well, it's now officially being allowed to continue under federal court approval. Let's break down exactly what the court said, why it matters, and why this means, and what this means not just for New Yorkers, but for every one of us across the country. Now this case, it's New York State Firearms Association versus James, Letitia, and it challenged three parts of New York's so-called Concealed Carry Improvement Act, or the CCIA. Specifically, it targeted the state's ammunition background check system, the $2.50 fee per transaction, and the requirement that ammo sellers register with the New York State Police. The plaintiffs included New York State Firearms Association and several individual gun owners, some you may recognize, including state legislators George Borrello and David DiPietro. Now, these folks argued that the ammo background check system violated the Second Amendment by making it harder for law-abiding citizens to buy ammunition, a right that's clearly connected to the right to keep and bear arms. So what did the Second Circuit say? Well, in short, they sided with New York Attorney General Letitia James. The court affirmed the lower court's decision that refused to block the law. That means the ammo background check system stays in place, and gun owners in New York will continue having to go through the same system before they can buy a single round. Now, the judges said, and I quote, that the plaintiffs failed to demonstrate that the ammunition background check provisions meaningfully constrain their ability to keep or bear arms. Okay. Well, in plain English, the court just said that these background checks, the registration requirements, and even the extra fees, well, they're just minor inconveniences. The court doesn't see them as serious enough to count as an infringement on your Second Amendment rights. Sounds just like the Department of Justice, doesn't it? Well, the court's reasoning is pretty telling. They relied heavily on what's called the Bruen framework, and you've heard me talk about it before. That's the 2022 Supreme Court decision that said courts must look at the Second Amendment's plain text and then the nation's historical tradition of firearm regulation to decide if a modern gun law is constitutional. But the Second Circuit, like it's done before, completely twisted Bruen. Instead of starting with whether this law violates the plain text, your right to keep and bear arms, well, they said it doesn't even reach that step because the ammo background check doesn't meaningfully limit your rights. They called it just an administrative step. A modest condition, they said. A condition that you will not find anywhere in the United States Constitution. Even worse, they said delays, paperwork, or fees like these are presumptively lawful, just like other conditions on the commercial sale of arms. So, in their eyes, having to pay $2.50 every time you buy ammo and wait days or weeks for a state-run database to clear you is no big deal. And let me remind you, this system has crashed multiple times, denied lawful buyers, and delayed thousands of transactions. But to the court, that's just a minor convenience. What they've ignored, and this is key, is the real-world impact. The plaintiffs showed that gun owners were blocked from buying ammo because the system went down. They submitted declarations showing delays lasting hours or even days. But the court brushed that off, saying there's no evidence that the delays were lengthy enough to violate the Second Amendment. I guess if somebody got murdered by a criminal because they couldn't buy ammunition to defend themselves, then maybe the court, probably not. It's the Second Circuit. The court even said that because one of the plaintiffs had to wait one day, that was not long enough to count. Folks, think about that. You can have your constitutional rights put on hold because the government computer crashes. But as long as it's not too long, the court says that's just fine. It's not how freedom works. What if we told the judges that they lost their freedom of assembly or freedom of speech for a couple days because I didn't want to turn my computer on? I wonder how fast they'd move then. Now the $2.50 fee is another big deal. The court said it's okay because the fee supposedly covers the administrative cost of the background check system. But here's the problem. This fee gets passed down to you, the buyer, every single time you buy ammo. Buy a box of 9mm, fee. Buy another box or 3 next week, fees. Every time, forever. And they didn't stop there. They also upheld the licensing requirement for ammo sellers, meaning if you're not a registered ammo dealer with the state police and you try to sell a box of rounds to your buddy without going through a licensed intermediary, well, that's a crime and you can be fined or even charged for that. Freedom. So the court is basically saying that if you're not part of the government-approved system, your Second Amendment rights do not apply. The Second Circuit didn't even go through the second part of the Bruen test, the history and tradition analysis, because they said it wasn't even needed. Since they ruled this law doesn't meaningfully constrain our gun rights, they said there's no reason to check if it even lines up with historical firearm laws. It's because it doesn't. And that's a huge red flag. They're sidestepping the Constitution altogether. And in doing so, they've effectively rewritten how lower courts can gut the Bruen standard. They're creating a new loophole. If a gun restriction is inconvenient but not impossible, it survives. And that's how they're going to keep upholding modern gun control laws while pretending to follow Bruen. The court even took a shot at the Ninth Circuit. Remember the Rody v. Bonta case in California? That's the one last July where the Ninth Circuit struck down California's ammunition background check system as unconstitutional. The Ninth Circuit. The Second Circuit said that they disagree with that decision. The judges basically mocked the Ninth Circuit for saying background checks and fees are unconstitutional. They said New York's law is totally different, and they doubled down that minimal fees and short delays are just fine. Once again, instead of looking at the right to keep and bear arms as a guarantee, they're treating it like a government permission slip. So what's next? Well, the case isn't over yet. The New York State Firearms Association can still appeal this ruling to the Supreme Court, and frankly, it should. Because if this decision stands, it will give other states like Illinois, Massachusetts, and New Jersey the green light to do the exact same thing, to regulate ammunition just like firearms, turning every single ammo purchase into a government-tracked transaction. This is how the anti-gun states will get around Bruen, or try. If they cannot ban guns outright, well, they'll just choke off access to ammunition. Patriots, let's be clear. Your right to keep and bear arms doesn't mean anything if you can't buy the ammunition to use them. The Founding Fathers did not fight at Lexington and Concord with muskets that had no powder or no shot. The ability to acquire ammunition is a fundamental. It doesn't get any more fundamental to the right to keep and bear arms if you can't utilize them. And what the government tries to do here is shut down our access to ammunition with computer crashes, delays, or arbitrary fees. It's not about safety. That's 100% about control. This is why we need to keep fighting, because every single court, like this clown, this group of clowns in a second, will chip away just a little more, normalizing infringements under the excuse of public safety or administrative convenience. Subscribe to this channel if you want more updates on this and all the other instances where governments try to take away the one right that secures the rest. And remember, Patriots, every right that we don't defend today becomes a privilege tomorrow. Before we wrap up, I want to take a second to thank today's sponsor, Blackout Coffee. If you want to support American-made, freedom-loving businesses that share your values, head on over to blackoutcoffee.com/GNG and use my code GNG10 for 10% off your entire order. Wake up every day with a cup of liberty. Until next time, stay safe, stay vigilant, stay armed, and stay free. God bless y'all. Take care.